Hello, welcome to our periodic webinars in the Syracuse Technology Law Program and Intellectual Property Law Institute series. This is Professor Shubha Ghosh at the Syracuse University College of Law, and I'm very pleased to have with us today Professor Amy Semet at the University of Buffalo Law School, who does some very incredible work in the area of empirical studies of administrative agencies. I think you have some papers, for example, in the immigration area. And now we're developing databases in the patent area, not just simply patent litigation databases, but also ones associated with the Ptab. So welcome, and look forward to learning about your work.
Yes, thank you very much for inviting me today to talk about my patent law project. I will start my PowerPoint where I am discussing some of the work I'm doing with respect to starting a patent law litigation database composed of decisions from both the Patent Law Administrative Agency, from the district courts, and the Federal Circuit. First thing is the Patent Trial and Appeals Board formed in September 2012 as part of the American Invents Act. It's a predecessor from was the Board of Patent Appeals and Interferences. There was a lot in the news and the Supreme Court jurisprudence recently about the constitutionality of Ptab judges, and this is an area that the Supreme Court's going to look up again about examining Ptab judges in their later in the Supreme Court later this year. But we still don't really know a lot about who these judges are and how they make decisions and how their decision making may compare with those of the district court. You know, there could be pending district court cases challenging the validity of a patent or alleging infringement in district courts. And these court decisions could be before or after the Ptab decisions and by different parties. So in part of my analysis, I'm going to examine how the Ptab decisions may differ from the district court decisions. To begin my project, I am in the process of collecting Ptab judge data collection. I obtained the CVs of about half the Ptab judges from the PTO. And I've used Python text analysis to scrape the CVs to develop a text file. So I'm able to get more information about the judges and also follow up with information from LinkedIn, law firm websites, as well as other public resources to find out more about the demographic features of the judges. I'm currently in the process of doing another FOIA request to get the other half of the judges, to get the CVs of the other half of the judges. So what is the type of data I'm collecting? Their gender, their law firm experience, whether they were partner or of counsel, their age measured by their college graduation year, where they previously worked at the PTO, such as a patent examiner or worked as a patent attorney or worked at a solicitor's office, whether they had other government or military experience, their scientific expertise, such as their undergraduate degree, whether they had a master's degree or PhD, as well as the subfield of their bachelor's degree, their previous scientific experience, such as if they worked in in-house counsel as an engineer or in a laboratory during part of their time period before they became a Ptab judge, their law school, where they're from, what member of some of the CVs tell you what member of the bar what state member of the bar they're from, and potentially other data, such as race, ethnicity, whether they were patent holders, whether they had published applications or not, published articles or not. So in conjunction with collecting information about the judges, I've also collected information about the cases from a variety of sources, from Lex Machina, Docket Navigator, Unified Patents, the PTO website, and planning on doing some type of text analysis on the main documents to obtain more information about the cases. So the PTO itself has a very great interface on their website where you can collect a lot of information about the Ptab decisions. There's about a little over 12,000 current decisions, and they tell you what's the patent in suit, what's the technology, what's the current status, like whether it was instituted or not. The way it works as a Ptab is the Ptab will decide whether to institute a decision, and then it will, if it's instituted, meaning they're going to hear the case, then they will decide an outcome. And they focus on validity decisions, particularly validity decisions dealing mostly with obviousness under 103 or anticipation under 102, such as whether the prior art anticipated or made obvious the claimed invention. I'm also planning on collecting information about the claims in suit and the prior art. The Ptab databases don't give you that particularly, but you could do more text analysis to be able to easily collect that information to see what claims are being instituted or decided and what was the particular piece of prior art. The judges, there are usually 3 judges on a panel. The judges that are on the instituted panel may differ from the outcome panel, and then there's a chief judge of the panel, and they will issue oftentimes a written decision. The parties and the patent owner, the law firms involved, as well as the people, the law firm lawyers involved, like I said, the statutory section, and then whether it's on appeal. And you can combine that with information from other databases or your own analysis of the litigation, as well as text analysis to see more about the technology in suit. In conjunction with that, I've also been working the past few years on collecting a database of district court and federal circuit decisions from a variety of sources. Lex Machina, Navigator, Unified Patents, PACER, and the USPTO also has a database of certain district court decisions up to 2017 or 18, I think. And looking at all those decisions to examine how district court judges make decisions, coding such things as the outcome, the legal issue in suit, like was it the best mode being decided, or was it a validity decision? If it was a validity decision, was it a section 102 decision or a section 103 decision? The parties and law firms, and then combining it with information from Patents View. Patents View is the USPTO website that has various databases where you can collect information about the patent, such as the NBER category, which is the National Bureau of Economic category, which has 6 subcategories of whether it's a chemistry invention or a mechanical engineer invention, in order to gauge the complexity of the case. The judge and judge characteristics, you can obtain judge characteristics of the federal court judges from the Federal Judicial Center, such as when they were appointed, who they were appointed by, their backgrounds, their education, and whatnot. The NPE Stanford database contains a database of whether the type of entity it is, like whether it's a university or a so-called patent troll or whatnot, and then connected as well with the federal circuit decisions. In addition, I've been able to also collect information regarding different motions and stuff related to each case, such as whether there's a motion to stay the case pending a USPTO or Ptab review, summary judgment motions, contested motions to dismiss, transfer motions, whether it's a bench trial or jury trial. So you can conduct more fine-grained analysis on how different judges make decisions on different types of cases, as well as the analysis allows you to determine whether something's a design patent or not. So I'm in the process of merging my Ptab and district court decision making 2 ways, by the Ptab decisions and then separately by district court. So you have a wide view where you can see the district court decision and then whether there's a Ptab decision that's either before or after that district court decision, and then a wider, the long view, which is by patent, which tells you each patent and whether there was a district court or Ptab decision, as well as whether there's a federal district court decision. So there's about over 6,000 cases in which there's something going on. So as part of my research, I'm going to examine how the district court and the Ptab decisions may differ. Now, my preliminary analysis of the Ptab judges yields some interesting information about who these judges are. Like you mentioned, some of my prior work examines administrative agencies in general. I've done some work with respect to examining how the National Labor Relations Board makes decisions, as well as how immigration judges make decisions. And I've collected, I have a similar database on the immigration courts, which I've examined how, and I collected demographic information about immigration judges to see how their demographics may impact whether they grant asylum or not. So I'm doing a similar analysis with the Ptab judges. Like I said, I've not gotten all the CVs yet of all the Ptab judges. I have about half so far, and my preliminary analysis of half the CVs, assuming it's a representative sample, but it might not be because it's not random, but the sample I have so far of about half the the judges. About 38% female, 23% were previously examiners at some point. Oftentimes, some of the judges were examiners right before they became a Ptab judge. 13% were Ptab lawyers or worked as solicitor's office. 19% former federal circuit clerks. 85% had some kind of private practice experience, and that varied. Some of them maybe only had 1 or 2 years at a law firm. Some of them were partners at a law firm. 40% had some experience as engineers or scientists. 45% engineers, scientists, and then I included those who were general counsel to a scientific company. The median age was 48. 74% were from not T14 law schools, and 29% were from DC area law schools. So of their fields of study, they have a diverse field of study, as this graph shows. So you see a large percentage of them. I mean, if you would look at the fields, biology as well as electrical engineering are some of the major fields of some of the Ptab judges, as well as mechanical engineering. Now, I've also preliminarily examined their career paths, having different types of career paths, whether they come directly from the PTO, such as working as a PTO examiner or working as a lawyer for the Ptab or working otherwise as a lawyer at the agency, whether they're serving as a judge is the culmination of their career, meaning that they maybe were a law firm or a general counsel for many years, and in their 50s or 60s, they later become a Ptab judge. What I would call new judges, which are ones that maybe only served for 1 or 2 years or 3 years at a law firm, and then they become a Ptab judge. And then ones that come from science backgrounds, that they would maybe have been a scientist at a company and then moved into the Ptab judges. So you see the biggest types of judges are 40% are the culmination judges, which are judges that come into being a Ptab judge after serving a quite long career in patent law. And then the second category being the new judges, the ones that would maybe only have a couple years of experience. So you see the two different ends of the spectrum with respect to the judges. And the third category being about 15-20% of the judges being ones that would have worked in the agency at some point, usually as patent examiners, but sometimes also working as lawyers at the Ptab or the agency. So
can I interrupt for just 2 questions real quick about that slide or in the previous 2 slides?
Yeah.
Do you have a sense of how many were members? Do you have to be a member of the patent bar to be a Ptab judge? What exactly is that background? I guess you have to be a member of some bar, or do you know?
Yeah, I think they are almost all members of they're all lawyers, and I think they're all members of the patent bar. I mean, at least all the CVs I've seen, all of them have shown that they were members of the patent bar.
And then as far as bar membership, do you have some breakdown? You mentioned many, 29% were from DC area schools. Are they sort of Northeast, West Coast? Are they pretty distributed in terms of bar membership? State bars?
A lot of them are coming from the Virginia, Maryland area. Yeah. Most judges, when I measured the 29%, they was based on the law school. So I looked at the DC area and Maryland law schools, and most of them, like almost a third of them, had gone to law school at George Mason or American or George Washington or Georgetown or one of the other DC area law schools. But that's an interesting point to look at. What was their immediate prior job. There were judges that do come from, say, a law firm in Illinois or a law firm in California, but that's an interesting thing to perhaps add to look at where their immediate background was before they became a Ptab judge. That's an interesting thing to. In
terms of regional, because some of them they're housed all over, right? Some of them are in the satellite offices as well. I know in the Dallas office they have Ptab hearings there. I assume that's true in the other satellite offices as well.
Yeah, and the PTO is also an agency that does a lot of work that, in general, it's an agency that works remotely more than other agencies. So I imagine it would be something that in the future probably will be more open to increase the diversity of patent law judges, to not have them all necessarily be in the DC area. I would say probably the third figure representing law schools is probably higher. If I was just going to look at law firms, probably I'd say 40 or 50% are probably coming from the DC area in terms of working at law firms. Or like I said, a lot of them have worked as patent examiners as well. About 15% worked as patent examiners. So most of them are coming from the DC area.
And do you have a sense as far as the ones who clerked, which judges they clerk for? I mean, or is that something you're interested in looking at, or is there
Yes, I
some?
do know what judges they clerk for, like what, if they clerk to the federal circuit, I do know. So that's interesting to, another area to examine really would be how the ones who clerk for the judge may differ in terms of their decision making, how maybe, I guess the problem with that is that some of the judges may have clerked for judges that are no longer hearing cases once they become a PTAB judge. But that's interesting.
Yeah, I know we had the earlier, I think it's frozen again, so hopefully. I know some, hopefully this will resolve itself. Are you still there?
Yes, yes.
Okay, I think you froze for a minute. I know some earlier studies like Polk Wagner, I looked at, had this, I think these are in the early 2000s, where he looked at different categories or styles of judging on the federal circuit. And it'd be interesting to see if that somehow translates into styles of judging of PTAB judges, or if what they do is more ministerial rather than adjudicative. I don't know. So.
Yes, and also, well, that goes to the projects, different projects I'm working on.
Yeah,
really,
exactly.
Like I said, I have the text of the case of the decision, so one can do some type of text analysis to examine opinion writing in general. This is something I plan to do on with respect to PTAB judges as well as federal circuit judges. I know that some scholars have found that the federal circuit has two different styles of doing claim construction or whatnot, but it can be examined more robustly by examining opinion writing styles using text analysis to see if there is a different ways of judges writing decisions. So in general, my projects relate to examining really how are these PTAB judges deciding cases? Are they deciding cases differently by the district court? I mean, how do the district court outcomes differ from the PTAB decision outcomes? The specialization of the PTAB judges, ones that have, say, a degree in chemistry, are they hearing all the chemistry cases? And does specialization impact how they may make decisions? I've done some research with respect to that at the district court level. There's a patent law pilot project where there are certain numbers of districts, certain numbers of judges in certain district courts that hear the most number of patent cases. And I've examined whether they are reverse less on appeal at the federal circuit if they come from if the decision is coming from a patent law pilot judge versus a non-pilot judge. And I found no difference there, but it could be that there could be other metrics in which they differ. For instance, maybe pilot judges decide cases more quickly than non-pilot judges. Similarly here, how does specialization affect case outcomes? Like, if they have a specialized field in the field of invention, would they be more or less likely to find the invention obvious or not? So the information I have allows one to collect, because I have it on their CVs, what their undergraduate degree was in or their master's degree, and see how that affects their decision-making with respect to specialization. Like I said, how do the PTAB judges differ from the district court and federal circuit outcomes? I think that there's a lot going on with respect to, like I mentioned about the Supreme Court hearing this case this year about the Ptab. So, more information about how the Ptab is actually making decisions and how they really differ from district court and federal circuit decisions would lend insight not only to patent law practitioners, but also lend insight into how the administrative state works and how the administrative state has to deal with issues of expertise and democratic accountability, and there's an appropriate balance to have that. But empirics can shed light into how administrative agencies and administrative adjudicators in general make decisions. Secondly, just even with respect to the standalone district court database, what are some patterns in how district court judges make decisions? I know there's been some research that's done examination of empirically about how judges make decisions. For instance, how they made decisions before and after important Supreme Court decisions on obviousness, for instance. But I think a more comprehensive look of how judges make decisions and how maybe certain judges or more specialized judges are more likely to resolve cases by summary judgment, or what kind of cases are more likely to be heard in a jury trial versus a bench trial. how can text analysis be used to study patent law decision making? Is text analysis and natural language processing can be used to study all these district court and Ptab decisions and federal circuit decisions to gain more information about the cases themselves. And before without having text analysis or some of these databases, you had to like literally hand code all this stuff.
Mm-hmm.
Text analysis can be leveraged to gain more insight into the cases and also gain more insight into how judges are actually writing opinions. And then finally, how can the database and patent law and trademark and copyright law be utilized better to study issues with respect to gender and race and ethnicity? The PTO did a study last year where they looked at inventors, and they did a statistical analysis to, because the PTO does not collect demographic information on their inventors in their history. So one has to figure out using the name and the place, the location, one can do statistical analysis to figure out the gender. So they did that. So they have a database now where they have the patents and the gender of the patentee. And so one can do further analysis with respect to analyzing inventorship and gender. I think similar analysis can be done to study issues of race and ethnicity with respect to patent law and inventorship in general, and with respect to all these issues I'm studying in this database themselves. Are there panel effects? How does do judges of different genders or race, do they differ in their decision making on patent law cases? Who are the patent law litigants? Are there certain litigants that are more likely to file suit and whatnot? So there's a whole realm of research with respect to gender and race and ethnicity that one can examine with respect to patent law. And that's a new and exciting area of research. In addition, I plan to also, after I do a lot of the patent laws, also examine some of these issues and similar issues with respect to copyright, trademark, and trade secret to see how those types of case law may differ depending on how the administrative state and trademark law is at the district court and whatnot.
This is incredible. So thank you for sharing all this. I guess I have comments and questions, I think, just to flesh out some of the things. So I guess starting out with the most basic one is, where do you get the time for all this work? What's the strategy for collecting and putting together this data set? Do you have a slew of research assistants, or do you have bots out there that are downloading these things? I'm sure you have a combination of all of those. So how would you advise someone doing empirical work on
Yes, I've been working on this for a few years. And before I became a faculty member at Buffalo, I had a research assistant last year when I was teacher at Columbia, but only for a number of hours. I have funding this year from the Boldy Center at Buffalo to help me with some of this work. But it's a labor intensive task. And even when you make the database up, you need also to go back and check the database because I've eventually plan to make the database public for other researchers to use. So, I have some research assistants that help me now, and I also do a lot of my own work. And also, I also read all the cases myself, which it doesn't seem as daunting as it sounds, because a lot of these cases, particularly cases in the Eastern District of Texas or cases filed by patent trolls, although there may be, say, 80,000 cases, a large percentage of those cases are cases that are resolved in settlement or that never really advance beyond the settlement discussion or whatnot. There's not really much, and the same patent is at suit for like 10 cases. So that saves up a lot of time to be able to do that. In addition, leveraging text analysis, I think, will enable me to perform confirmatory checks on some of my work. And using different databases, even if I'm not using them as my main source, using these other resources serves as a confirmatory source on some of the work that I'm doing myself or reading myself. The most important thing, I think, is cases in which there's multiple outcomes. Like, for instance, maybe one patent is resolved at trial. Maybe one patent is resolved by summary judgment. Those are harder to analyze because the certain databases may only give you one outcome, so you have to go back and look at them. But those cases really are in the minorities, only maybe a few thousand of them. So there's not really that many cases in which one really needs to spend a lot of time analyzing the
Yeah.
case.
And what tools are you using? You mentioned you mentioned Python, which I'm getting some familiarity with myself, and thank you for your pointers on that direction. But what other tools have you been using for some of the text scraping, or when you're just reading the cases? Do you use DBase? Do you use Atero? Any thoughts there for researchers?
No, I'd be interested in your thoughts. I create the base database using Stata or R,
Yeah.
and then create merging different things in through there, and then I read the cases, and then I just do them, just read the cases and then input whatever I need to input. What are some of the databases things you just mentioned?
The database, I use Zotero for mostly bibliographic things, like for preparing book manuscripts, and I think there's a feature there that could be amenable to combining cases as well, even though that's not what it was designed for. I found things like downloading cases from Westlaw or from these other databases to a spreadsheet helpful, but I know that's fairly primitive and that doesn't cover a lot of things. But Stata, I'm getting some familiarity with, R less so, but I found those very helpful. I think I love the data management. I mean, I'm obviously into the tech, but there's part of me that still is very, I need to read stuff and have a yellow pad and take some notes at some level. But I mean, that can only go so far. But I find that some of the things you mentioned in terms of the programs like Stata and Python very useful for these types of text analysis and so forth. It's just the hard part is just keeping it straight. I think just having a very good methodology for figuring out exactly what goes where and how and so forth. So, did you have any pointers about that, or did you?
Yeah, I mean, like for database management, I think especially for a beginner person, Stata is the most intuitive rather than R.
Yeah.
R is more used. I would use R for maybe more like when I do more sophisticated statistical analysis, or if one was going to do, say, network analysis, where if you wanted to examine networks between lawyers or whatnot.
Yeah.
But I think Python and is more used if you want to do text analysis and natural language processing, because that's not really, I mean, there's maybe a way to do it in Stata, but for the most part, most people will use Python to do that type of stuff, where you can just, and also I use some software like Adobe has it, but there's also other software where you could take the PDF and batch convert PDFs information into Excel spreadsheets. And then once you have an Excel spreadsheets, then you can use it in Stata. But the text analysis really is something that one uses Python for that.
Right, and I've been finding that very helpful with the assignment databases I mentioned, and just sort of sorting through cases a little bit and then trying to organize that. But it's really interesting in terms of just thinking. I mean, I've taken maybe not taken very sophisticated computer science classes, but it's gotten me thinking more about the intersection between law and computer science. Just the classification, just the things in law we take for granted, but somebody must do, and that we're sort of implicitly doing, even though we don't, may not really acknowledge it fully, that when we have to do this sorting function as lawyers all the time, as law professors and legal scholars. So this is really, making you confront that issue in a very, elemental way. It's pretty exciting, I think. So. Let's talk about some of the projects you have are really pretty amazing. Let me just, based upon your earlier work on the NLRB and the immigration law judges, do you have any priors about what you might glean from that previous work about patent law? I mean, obviously I don't want to. This is preliminary, so I'm trying to phrase this in Bayesian terms in terms of what hypotheses you might have going into the work.
Well, I think that the broader issue of how specialization impacts decision making, both of the Ptab and the district courts, are there certain judges that are more likely, are specialized judges, or judges that they're either part of the pilot program or that have more expertise in patent law cases? are they more likely to decide cases differently? Like, for instance, are they more comfortable deciding cases on summary judgment than ones that maybe don't have as much experience?
Mm-hmm. Mm-hmm.
I think with the Ptab, looking at specialization of the judges themselves and their scientific background, like would be the case that those who have, I mean, you would think that maybe those who have a chemistry background deciding chemistry cases, maybe perhaps maybe they would, you know, usually maybe a high level of skill would be more likely to find something obvious than someone who has a low level of skill.
Yeah, yeah.
Does that play out with the judges themselves?
Right. And that's something, so it's the scientific expertise that would distinguish your PTAB studies from what's going on in the NLRB and the immigration law judges. Is that, I guess it's a fairly obvious thing to say, but is there a role of specialization in the NLRB and immigration law judges as well? And obviously that's scientific specialization, but the fact that you might have been pro-labor, pro-corporate in practice for immigration law judges, maybe obviously, you know, the background of the judges themselves as to whether they were in fact immigrants or had some experience with the immigration system. What's your sense of just the notion of expertise and administrative judgment, if you will, for lack of a better term?
Yes, with respect to, well, in the patent law context, there's very few district court judges, like just looking at their backgrounds, that have scientific backgrounds or at least scientific BAs. So if you were judging expertise by that on the district court level, there's really not a whole lot of judges that have a lot of scientific background. Now, with respect to other agencies and the administrative work that I've done with Catherine Kim, I've examined, for instance, a lot of IJs, immigration judges, served as prosecutors or worked at the ICE. Approximately 90% or whatever had some kind of ICE experience or immigration enforcement experience. So because so many of them have experience, it's hard to dissuade the effects between specialization in that respect. But and the analysis that I found with respect to immigration judges was that it did not affect their decision making. But again, that could also be because so many of them have that experience. That's more likely that you're special if you don't have prior government experience. Though I think I plan to look at more fine grain by looking at particularly whether they were ICE prosecutors rather than just worked at the DOJ. You know, so there's ways that one could look at that in a more particular way.
Yeah, yeah. And I guess the interesting thing about this as well is to what extent the underlying law, the regulations are rule-like. I mean, maybe they're more rule-like in immigration than they are in patent law, and perhaps NLRB is somewhere in between. I mean, just from my little experience in those areas. So there's that aspect to specialize. I know Miriam Britton, who's a scholar at Bar Ilan, has written about sort of race and gender in trademark decision making. And one hypothesis, and she's compared it with what goes on in patent law. So this is kind of ties into the last point that you had on your bullet point, your PowerPoint. But one of the hypotheses she says is that in the trademark area, there's less discretion than in the patent area when you're looking at, for example, the administrative side of this. I mean, it's obviously different in the judicial side. And so I'm wondering about that as well. Do you have a sense of certain areas being more prone to discretion than other areas? I mean, obviously there's a judgment call there, but is that something that's also at work when you look across these different agencies?
Yes, and also the PTO provides a nice case study in contrast to the NLRB and the immigration, because it's purportedly a less political agency and decision making's purportedly in patent law. There's not been a whole lot of research to the extent to which ideology impacts decision making, like for instance, how does being a Democrat or Republican affect one's opinion on innovation generally. So I think with respect to immigration courts, for instance, there's a lot more discretion with respect to, and because the statute is very vague, there's a lot more discretion with respect to whether the person will have to be removed or granted asylum or not.
Right.
And also there's a political input to that. And that's what our research, my prior research in immigration law found, that Trump judges, or judges, not really Trump judges, but the decision-making during the Trump era was different than the decision-making than the Obama era across all appointees, no matter if they were appointed by Trump or whether they were appointed by Obama. With the patent law, you don't necessarily have that political dimension to the decision-making. With respect to patent law, the patent law statute is very vague. And it's not necessarily clear how things like obviousness and be decided.
Right.
Things can be, there's probably more discretion or more politicalization that goes on in other agencies than may go on at the PTO.
Yeah. I mean, I think the point that Professor Britton had is about, for example, certain clear exclusions under trademark law, for example, like geographically misdescriptive, or for, I don't know, I'm trying to remember, like the likeness of a president or something like that. I mean, there's a clearly stated in the trademark statute. While patents, as you just correctly pointed out, you have things like non-obviousness or even subject matter that, that makes it a lot more room. I don't know for politics, but at least for the discretion of the judge. And they may go back to things that are familiar, like their scientific training or their experience, to try to get a handle on that. So it'll be interesting to look at.
And some issues more politically charged, like what is patentability? There might be more issues with respect to things like embryos and stem cells and things like that. There might be more issues with respect to more of a political dimension on some of those issues than with respect to just
the morality issue. And I think your database is only going to go back to 2000, so the historical dimension is there. But I know, for example, like in the turn of the last century, so in the 1900s, there was a lot more restrictions on morality, both in patents and in trademarks. So, which we don't really have now. I mean, so I guess it would be interesting to see whether the movement away from these focus on morality, so you see that in some of the federal circuit cases, like Juicy Whip, whether there's a political dimension to that as well. That the idea of making things less political itself has a political aspect to it, is something to think about, I guess. Has anybody done a study like you were doing for the Ptab? I was just curious. I mean, is that something on your, after all the free time that's going to open up when this project is done?
Well, there's been some preliminary work that was done in the first couple of years of the Ptab in 2012, 2000. I know Brian Love has done some work.
I said the Ptab, the trademark side of this.
The trademark. Yeah, I'm not as familiar with that. I mean, I think that there are some work, like I know that there, one of these conferences I went to this summer, there was someone who examined the race and ethnicity issues in trademark cases. So I think that is a little bit more, there's probably actually a little bit more in the trademark law.
Yeah, that may have been the Miriam Britton. I know she has a paper on that and with her co-authors. But yeah, I'm just curious about. I mean, this is just such a rich area, and the Ptab is. We've had a lot more history with that, obviously. So, it'd be interesting to do some contrast on that. One aspect. Just thank you for taking the time to talk. I just have kind of two more points that may be worth talking a little bit about. I mean, one aspect of the database, as I see the design, is largely on. Looking at the decision makers, so the judges and so forth. One aspect that I've always been curious about with the Ptab, I try to do some preliminary work, is the use of the process. So I was, early on, I was interested in the role of settlements in Ptabs, and whether, companies, patent owners are using the process strategically. I think this comes up a little bit with the NPE literature as well. I didn't see that, or maybe I just missed it in your list of projects, but how does the design of your database lend itself to looking at the perspective of the user, if you will, the patent owner and the people in the industry and inventors, in terms of identifying how these processes may be being used strategically, or maybe using the way in which Congress intended them to be used, in which, i.e., identify bad patents you know, separate the wheat from the chaff. So is that something in the design of your database? I didn't really fully catch it if it was. So.
Yeah. One of the things I plan to also do is kind of a descriptive analysis of who was actually using these Ptab proceedings, and mapping out, for instance, when I'm analyzing the district court outcomes against the Ptab outcomes, analyzing who are the parties, are they NPEs that are doing this, who are the people that are filing, who are the people who are filing both in district court and in the Ptab proceedings? Who are the people who are just filing first in the Ptab proceedings? Like, I'm examining, that's kind of a separate analysis as to examine who these parties are. So I think once you have the database and you have all the outcomes, and there are a lot of settlements in these cases, you can examine, are there certain parties that would be more likely to settle some of these cases than others? And when they settle, do they settle, for instance, in conjunction with the analysis, I'm collecting also information about the claim construction hearings and whatnot. When there's joint, if there's a pending district court decision going on at the same time as the Ptab, are they settling into the claim construction ruling? When are they settling? I think the timing of settlement, like, if the district court makes a decision on something like claim construction, is that not forcing them to settle, but are they more likely to settle? Is that the time when a lot of these entities settle once they get a claim construction ruling that may be not positive for them?
Yeah, or settling in the Ptab stage, so it precludes a finding of some sort of adverse judgment, so your patent doesn't get invalidated. And I thought about this in the context of the Actavis and the reverse payment cases in the pharmaceutical context, and whether Ptab might facilitate some of those practices, or to a certain extent. So this is really great. This is fantastic. You mentioned the Supreme Court case that's pending. So I guess you've got to get the pontification of law professors on any pending Supreme Court case. So I think that's sine qua non of these podcasts. So do you have any thoughts about that case and how that might either affect Ptab practice or your research, or?
Well, I'm not sure really how it will affect. I think that the current case is probably on a pretty narrow question, because I think the oral states case dealt with somewhat the broader question of the constitutionality of Ptab judges. But I think that just going forward, especially as we get a Supreme Court that would be a more conservative court, and a court that maybe would be issuing decisions that would be different than they have previously on the administrative state. I think that research into how the administrative works would lend insight into how the administrative states should be reformed, or is the Chevron doctrine, which I've done some work with respect to labor law and the Chevron doctrine. And for the most part, the Chevron, a lot of these cases are just, they say Chevron, but then they don't really apply Chevron. So is Chevron need an updating, or whatever the standard is for reviewing administrative agencies? Does that need updating? I think I haven't worked out how it needs to be updated or how. But I think research like this into how agencies actually make decisions and how they're reviewed by district courts and the appellate court with an insight into what would be the appropriate doctrine into how courts should supervise administrative agencies. Is it time for Chevron to be revised, or for our standards to be altered? If we know exactly more about the outcomes.
Yeah, I know there seems like there's a lot of give in the Chevron doctrine as to when a statute itself is ambiguous or not, right? You follow some of Scalia's decisions on that. He's very quick to find something relatively ambiguous or not ambiguous, depending on where he wants to come out. I think the Arthrex case, I think I have the name of the case right, that's in front of the court, has to do with how the Ptab judges are hired and who makes that decision. So I don't know if there's what the practicalities are of that. I should have probably disclosed that my brother-in-law's a Ptab judge. So there's some talk from there about how that's going to affect at least just the position more broadly, not just in his case, obviously. But it might have some interesting questions about the politicization of these Ptab judges, right? As to whether they're, Article 3 appointments, or how exactly that has to work. So that might be interesting to see how that plays out. But, But thank you. This is really great. I'm looking forward to seeing we're all looking forward to seeing the database and the publications. But this is such a great project. So thank you for taking the time to talk with us. Any concluding words of advice for budding empirical scholars in IP or other areas of administrative law that you
Well,
can leave us with?
Well, thank you for inviting me today. I think that a lot more empirical work can be done with respect to the administrative state and with respect to patent law and intellectual property law decision-making more generally, so as to inform how these institutions can best be reformed and how, what is the proper way to balance out the administrative agencies and the district court decision-making. The PTAB, really only is in existence for the last 8 years. And I think there's time for research really at the 10-year mark to say really how it's working and how it's making decisions, how its decisions compare with respect to district courts and whatnot. So I think this is a fruitful area of research. Empirical research in law in general is a fruitful area of research, but I think in particular this area of law is an area that will be an exciting area for years to come and probably have some interesting Supreme Court decisions along the way.
Great. Well, thank you so much, Professor Semet. Have a great afternoon. Thank you.
Thank you.